There we go. I think we're good now. Did take some warm up time. It must. Yeah, mine's got power.
Shut it off and turn it back on. It solves everything.
Yeah, just keep pushing buttons until.
Read one or two.
Right there.
Oh, there it goes. Okay.
Okay, time being, 3:03 now. We will call the meeting to order. Start with a roll call.
Marquardt,
Here.
Heine,
Here.
Barkle,
Here.
Loest,
Here.
Nelson,
Here.
Welsh.
Here.
Okay. And it's just going to pull up the agenda here. I had it. Oh, I thought I had it in here.
Is it Indian two view?
There we go. Nope, that's the wrong one. Too many agendas I have on here. My internet's being slow today. Okay, I'm not able to pull up the agenda again. Are you able to get the agenda up?
I no, I have it. Is it on in two view?
Yeah, I was just trying to pull that up, and TView is not.
Under
connected.
commissioners files or?
No,
Gary's got copies.
You got a copy? I thought I had it downloaded already. All right, well, so the first thing is approval of minutes from the last meeting.
I'll move approval. Second.
Second. Moved in second. All in favor, say aye.
Aye.
Opposed? Okay, passes. And next is approval of agenda.
I'll move
Any-
approval of the agenda.
Second.
We have a motion and second. All in favor, say aye.
Aye.
And opposed? Okay. All right, so then we'll open it up for public comment at this time. Okay. We will close public comment, and then we will move to our discussion of the solar ordinance. At this time, I think today we really want to focus on the idea of decommissioning and environmental and decommissioning. So I think we'll start it off with that open format that we've been doing.
So I think in the proposed ordinance, Gary updated it for our discussion last time. Under the performance standards, under H, I guess the endangered species and wetlands thing is kind of the first thing in order here. On all that stuff that Gary sent, by my reading of it, unless it's actual threatened or endangered species they determine is there might be something with FEMA or the EPA, but there's not really a requirement by South Dakota. you can do an optional or elective like stewardship plan, or you can ask the game fish and parks for an environmental review, but there's nothing required for actually in South Dakota. South Dakota doesn't require you to actually do anything. So I guess my way of thinking would be that if they are required to submit a report to FEMA based on that stuff that Gary sent, I think we'd want a copy of that at least, see what they submitted. And then we could potentially require them to obtain a environmental review through South Dakota GFP. It looks like it's pretty easy that you pretty much just ask them to do one and they do one for you.
So,
And I guess that would be pretty much what it looks like to me, is they would just be determining if there is any endangered species or anything like that in that area. And if we're looking at possibly disrupting 1,000 acres or more at a time, maybe that'd be a good thing to require.
yeah. And that is something that becomes required when you have a large farm, and I think in the PUC range. And so we're just kind of taking those requirements and extending them downward.
Right.
So as it's worded, you know, Game Fish and Parks requirements, would we then put South Dakota Game Fish and Parks that we require an environmental review? Is that what you're
Yeah,
saying?
that's what I would say, because the way it's
Okay.
worded right now, applicant must meet all South Dakota Department requirements, but there are no requirements. If you were at where the PUC was gonna regulate you at 100 megawatts or more, then you'd have to get it, but if you're under 100 megawatts, then really you don't have to do anything. So I think that if you were going to be under that 100 megawatts, that we'd still want you to do that, because you could potentially, I mean, if you use the figure of, if you've gone anywhere between 7 and 10 acres per megawatt, but just say 7, you go even 50 megawatts, that's what, 350 acres? That's pretty large
expensive,
area.
yeah. Yeah, because, like, as I says, endangered species meet all Department of Agriculture and Natural Resource requirements, and like, I don't think there really is a requirement at this point unless we put a requirement there, so.
Right.
And so we would require a environmental review.
By the South Dakota Game Fish and Parks.
Yeah.
I think that would pretty much cover it, because if they determine that there's something there, then they'd have to submit papers to FEMA as well, but, I guess we would be aware of anything then, if they would just do the environmental review.
Mm-hmm. Would it, and other than endangered species, say like water erosion type things, is there any, do we want to put any requirements there? Or do we need to specify anything?
Well, I guess in D on ground cover, we have soil erosion and sediment control. As far as that goes, or are you talking about?
Just as a I guess, so that, well, okay, I guess that does require I was just looking through all the different things that we had with DNR and game and fishing parks and stuff like that. I was just looking at seeing that there's also reviews for soil and water for other things. It's like, would that be a requirement we have here?
I guess. As far as the endangered species and wetlands, I think the environmental review thing covers that, but I don't know if the other
Okay.
reviews of soil and water, if that is anything different, or if that's all kind of encompassing in the review, or what.
Should we leave that up to the planning commission to figure it out? I think the focus today was decommissioning, and
Yeah,
I'd rather get on that first and then come back to this.
Yeah, I
if
think we
have
can
time
get-
at the end of the meeting.
yeah, I think we can come back to it. It's kind of open-ended. I don't think we have a reason to actually require it yet, but the planning commission can add it in there if they feel it needs to be. Yeah, so let's go on to the decommissioning.
So what's not in this wording of the decommissioning plan in our proposed ordinance here, is basically something that is to the effect of that we need an estimated cost of decommissioning with a financial plan attached to it. And I saw that was kind of a theme in some like PUC stuff, or like Pennington County one, or where basically you say, we think it's gonna cost this much, and here's how we're gonna provide for that to complete that plan. So I think that we need to add something to that effect in here.
So first, what's the difference? I mean, the ones that I've gone through, some of them have escrow accounts, some of them have, what's the difference between, because I know, John, you had mentioned, what did you say? You said
There's surety bonds.
yes.
Yeah.
So
which
what's
is
the
basically an
difference? Yeah.
insurance that you can buy a surety bond for $100,000.
Okay,
It's good for 1 year. You gotta renew it every year, just like your auto insurance policies or anything else. So if they decide that they wanna quit paying their surety bond expense, the surety bond goes away. An escrow account is, they put so much money in an escrow account,
okay.
it's there. If we're the beneficiaries of that escrow account, then something happens, the money is ours to do with what we need to do the decommissioning on. Now, you can set it up so the escrow account, they gotta add, if it's 100 acres, they gotta add $1,000 a year or to the escrow account, or something like that is how you can set those up. But the funding is there at the end, whenever they decide to not use it and it's gotta be decommissioned, the money is sitting there.
Okay.
Surety bond, the insurance company may go out of business.
And then you're left holding the bag.
Yes.
Could you, you have auto insurance and we're required to show proof of insurance every year.
What good does that do, though, if they decide it's sitting there for 5 years and they decide not to provide you proof of insurance? What good would something like that do?
That's true.
I mean,
That's especially true if the corporation that is operating the solar farm declares bankruptcy. There's really nobody to turn back on and obviously they would stop paying the insurance on the surety bond, so I like the escrow as well. I do think that rather than having a stated amount of $100,000 for any solar utility, that we would require the developer and operator to prepare a detailed cost estimate of decommissioning similar to the one that was included in the Wild Rose project out west, and that then the escrow account would be sized based on that. Because if somebody wants to put in a 5 megawatt system that covers 35 acres, that's very, very different than somebody who wants to put in a 100 megawatt system that covers 1,000 acres. So I think a detailed cost estimate, an escrow account to cover decommissioning cost, and that it should also include an escalator clause requiring the developer and operator to deposit additional funds each year based on an inflation factor that we could identify. One that comes to mind would be the Producer Price Index, which is published by the Bureau of Economic Analysis on a quarterly basis and on an annual basis. So that, let's say, for example, that the amount deposited in the escrow was $100,000, and inflation for that year in the Producer Price Index was, let's say, 4%, then the operator or developer would deposit an additional $4,000 into the escrow. That way we're not caught at the end of 10 or 15 years with an amount that would have been adequate 15 years ago, but it's not adequate now.
And that's another case with the surety bond. It's the amount that they buy the bond for is what you're gonna get at the end. With an escrow account, there's actually interest applied to that account, the money that's sitting there, and you can also apply, or, you know, the interest rate is probably a 0.08% or something like that, so you definitely would want an inflationary rate to build on that on an annual basis also. One other thing that I think we definitely need to look at and have in place is during the building process and at the end, we need to have a liability insurance holding us harmless and stating us as being held harmless for any accidents or anything like that that happens on the job site. And probably the landowner should, I mean, they would want that on their own also, I would assume. But as a county, I think we want to prepare ourselves or protect ourselves from that. So, and that's something that the designer or the producer should have that anyway to protect themselves, and all they gotta do is add us as hold harmless
So you're
to their
saying,
policy.
so you're saying the company and the landowner,
Yeah,
both?
yes.
If, let's say, for example, that we decide not to use the escrow account, but that we decide to use a surety bond, a backup would be that the county has the right to file a lien against the land upon which the solar system sits in order to ensure that the county is not holding the bag when the landowner was receiving lease income during the period of production. The landowner then should have some skin in the game, knowing full well that if this thing goes under, they will be held liable for decommissioning cost. So that scenario would be, we would have a surety bond. Maybe we would require the surety bond to have an escalator clause in it, but we don't have an escrow account. In that case, we should have the option of filing a lien against the land upon which the solar farm sits in order to make sure that the county is not liable for the cost of decommissioning.
So how much would you, if you had an escrow or if you had a surety bond, how much would you require them to have? Like, if we say that our estimate of decommissioning is $1 million, how much would you require them to have in the escrow account? $1 million? Or?
Yeah.
Well, I don't think that they would put $1 million in there the first year. I think you could spread that $1 million out over the life expectancy, 20 years of the solar farm, or half the life of the solar farm. And that's where the annual increases would come into play, so that at the end, the $1 million is gonna be there, or the estimated cost with inflation is gonna be there.
So what if you have the solar farm there and you say it's $1 million and you put in whatever 10% a year for 10 years, and 5 years in, then they abandon it and we have to decommission it and you're stuck with half?
80% of the panels is recyclable, aluminum and glass, where you can sell it to Jensen's down here for a price. So I don't think the balance would be that big of a deal to come up with. Yes, we'd have to pay some labor or whatever, but hopefully whatever they put in the escrow account will take care of that, and we can get reimbursed some of the cost through the recycling of the product. And
One, maybe a hybrid approach would be that in John's scenario, the operator or developer would put in 10% of the estimated cost of decommissioning per year, but that they would have a surety bond in place to cover the other 90%. And then the second year, it would cover 80%, the third, 70%, et cetera, so that we're never sitting in a situation where we have no likelihood of being able to decommission without the county taking a big expense. So in other words, that's another option.
I just, through our business, surety bonds has been not a really good, I mean, everybody's got to have one in the trucking business. But at the same token, if you have a load claim of $150,000 and you got a $100,000 surety bond, and the carrier decides to just shut the door or get another MC number, there could be 10 other carriers in line to get that piece of that $100,000. So even though the surety bond is for $150,000, we're not guaranteed to have that, to get that number. You might have somebody that sells them the solar panels. They get a chunk of that. You know, it's divvied up on a percentage basis. So.
However we do it, the reason that this is so important, at least in my view, is that I have never seen an economic analysis of either solar or wind energy that is economically viable. The only reason that these systems are being put in place is because there are heavy government subsidies, both for building them and for operating them and selling into the power grid. Just an FYI, in December of last year, the Lawrence Livermore Lab in California conducted the first viable nuclear fusion energy project. This is after many, many years of research and development. And most estimates are that this nuclear fusion technology for energy production will be at least in prototype form by the year 2040. So that's about 15 years from now. All of the technologies that we're talking about right now, whether they're wind or solar, are transitional technologies. And therefore they will go away. And just so you know, the byproduct of nuclear fusion is helium. And there's a shortage of helium anyway, so that would be a good thing. It does not have a long-lasting nuclear waste product such as fission does. And so we're probably about 15 years away from these technologies looking something like a Stanley steamer after Henry Ford created his Model T. So let's keep that in mind, that that is the real reason why we need to make sure that the decommissioning plan makes economic sense, because these technologies do not make economic sense, and they will be discarded when new technology becomes available.
So let's just maybe focus on the financial assurance part of the plan. Because there's a lot of aspects here on how the plan is created and developed, how the plan is updated through time. And then, but let's maybe just like focus in on, for now, the financial assurance part. Looking at some of these other ordinances from other counties, they kind of leave it open a little bit, mostly saying it could be any number of ways of showing financial assurance to the county, and leaving it up to the board to say whether they like it or not. Do we want to be more specific about what type of assurance we have?
Yeah.
Is
On
what
a
I think you're getting.
decommissioning issue, I don't want it to be open. I think that needs to be one of the most solid conditions in this whole ordinance. Like I said, it's too easy to say we're gonna do something, and we'll make sure 20 years from now that we're gonna pay for getting rid of this thing, and 20 years from now, you're not even available to write the check. I mean, that's why I'm saying that the only way that we should look at it is through an escrow account.
I agree.
And if they're not, if they don't feel comfortable enough in their plan or their project to put some skin in the game and put some cash in the bank for future uses to take it apart, then I don't think we want them here.
So, with an escrow account, the problem is it starts early on, it's gonna be insufficient. If we're only going, we can't expect them to put the whole decommissioning cost in there.
Correct, but
And
I don't
so
think they're gonna
We're
start the
talking maybe
project
something of a nature of,
50% or something. I mean,
mhm.
I don't think they'll start a escrow account with 50% of the money and then decide all of a sudden 2 years down the road that we're gonna quit and we don't have enough money to decommission it. I think we're gonna, if we take in 50% of it and we escalate it on a step program till we get to the end.
Because I was looking at some of them, they set an annual contribution, either based on megawatts or maybe based on megawatts or maybe based on acres of the project.
Because a surety bond is still gonna cost them a fairly large amount of money up front.
Mm-hmm.
So, and I can do some more investigating on where we think we should be at, but I think we definitely need to stick with an escrow account, and I think it needs to be at least 50% upfront of the estimated decommissioning cost, and then with an inflationary number built into that number, so that as inflation goes, because absolutely the estimated decommissioning cost today is gonna be different 20 years from now.
Well, and I was knowing that the Lynn County one has a clause in here that the decommissioning cost needs to be updated every 5 years.
I wouldn't have a problem putting that in ours either.
I think that's pretty good. If we did that and say also that maybe the escrow account, you have to have an escrow account covering at least 50% of the decommissioning cost. And then the other 50% can be left open to maybe be a bond or something like that to
Right.
cover.
And if a surety bond is any part of the mix, I think we should have language in the ordinance that says that the bond will be reviewed by the state's county attorney
Mm-hmm.
to ensure that the bond is AAA rated, and that and I think we also have language in here already saying that it would have to be an institution that is no, I don't think we want to have it so that it's local. The surety bond should be AAA rated, and it should be reviewed by the state's county attorney, if that's part of the mix at all.
Any other thoughts on that, or?
I just think that once one shovel of dirt is moved, whatever, that there needs to be money to cover everything. So like you think of the worst, you have to think of the worst case scenario. Solar company comes in, puts in, 1,500 acres of panels, and then all of a sudden they go kaput. And you think, well, why, you just never know. And here, I don't want the county sitting with only 50% of the cost of to put it in. I think we've got to have something in our ordinance to make sure that all the costs could be covered, so that the day that they're done putting everything in, that the funds are there to cover any type of work that needs to be done to decommission or take that out. And so that the county is not caught with any type of holding the bag. I just,
Yeah, and I think that's what we're going at is,
Yep.
that 100% is covered, 50% is in escrow, the other 50% has to be covered some other way of a
I agree.
surety bond or another way that may not require direct cash right up front by the company, but it still has to be covered before they start the
I
project.
agree.
And then we also, I think, do we all agree to having this decommission plan updated every 5 years as a clause as well?
Yeah, I think so.
Yes.
The one that I have here, and I don't know where I got this from, but they said it's reviewed if the company is sold. So for example, if the company that put it in is sold, that even if it hasn't been 5 years, it's reviewed.
Yeah, 5 years and/or.
Okay, yep.
Change of owner.
Transfer.
Change of ownership,
Or
whichever
transfer.
comes first.
Yeah,
Yeah, it says like within 30 days of change of owner of the facility, the owner will record and update the decommissioning plan.
Yeah.
mhm.
Yeah, and they say to the county register of deeds. This county has it on record at the register of deeds. I don't know what's the benefits of,
It's tied to the property, so then that's why it has the legal description, I suppose, for them to be tied, and that's the only way we can record something is if it's got, legal description on it.
Mhm.
So, it's recordable if it has a legal description.
so do you think that would be beneficial into having the ordinance that this decomp plan has to be registered with the deeds office of the county?
It's accessible to all the public then, that's one
Okay.
thing, I guess. I'm not sure any other really reason why it would be. We have no enforcement ability in our office, we just have it, kind of like a library, we have the records, so that anybody that wants to see it can see it, so I guess if somebody was interested, if it's recorded, then, it's available to them. And Brian would probably be a better one, I'm just going by what I, see.
Yeah, because there was no explanation, just says register of deeds, and so I thought, I was gonna ask that here to say why would they, if anybody would know.
A document can't be recorded with us unless it has a legal description, so, so it should, because, yeah, because it's on property. Yeah, so if it'd be tied to every property that it affected then, so if it came across several landowners, it would be recorded on each property that.
Let me backtrack just a little bit. If there is an escrow account, would it be possible to have that money deposited with the county auditor rather than in a bank? And then the county auditor could deposit the money in a bank of their choice? That's a question. I don't know what the answer is.
I don't even know that we wanna run that. I don't know that we wanna run that through our daily or our operation to start
Mhm.
with.
Gary, you said they do that with cell towers?
They did that with cell towers in the past, years ago.
Where they run the funds through our auditor.
Yeah, they would just keep it in a.
We got a hard enough time keeping track of our books the way it is.
It'd be no different than a TIF.
Yeah.
Everybody likes those.
Yeah.
Could run that by Patty, I suppose. before we- should rephrase that statement. I have a hard enough time following that.
Okay, so, is there any other thoughts on the financial assurance?
So what were you thinking? Something like 50% upfront and then increase that by the rest of the 50% over the first 10 years? And then, so by year 10, you've got 100% in there. Then they have to basically top it up with, for the inflation adjustment each year. And then in those first 10 years, whatever the balance that isn't in there you need to have a surety bond for.
I would say
Mhm.
yes.
Yeah. Makes sense.
Yeah, I think it'd be, and then naturally, every 5 years, we're updating the cost, so you're 5 years in, the cost may go up, so that means then your contribution should go up to try to still meet that 10-year limit, to have it 100% in escrow.
So our goal is by year 10, you got 100% in escrow, and then after that, you're gonna update it every 5 years for updated costs and everything, and in the meantime, you're just gonna adjust it each year for inflation.
Yep.
I think that sounds pretty fair to me.
Yep.
And so that would kind of be worded, essentially, you'd start with 50% escrow, 50% covered by other means.
Mhm.
And then every year you would be contributing 5% of the decommissioning cost into that escrow.
And your surety bond could drop by 5%.
And your surety bond could drop by 5% then.
Yeah.
Okay, now on developing this decommissioning plan and costing it, obviously, we would want to see this before we approve a project. I was noting in here, it's like, okay, obviously, commissioners, planning, we're not all experts on solar farms. We could all be, it could be a wholly different crew in 5 years, evaluating one of these. I was noting in one that they had a requirement, or if it was necessary to have a third party to evaluate the decommissioning, that costs for maybe a third party engineer to look at the decommissioning plan. That cost would be borne upon the applicant.
It's a good idea. Yep. That way you
I think
have some assurance that the cost estimate is legitimate.
Yeah.
I think that would be almost a necessity that it be a third party.
Yeah.
Mm-hmm.
A good CPA firm can do it.
Well, to get a cost estimate, and I don't know if the CPA firm's gonna be able to do that. They're just gonna have to hire an engineer to.
Lynn County
What do you know
listed a
about solar?
professional engineer.
Yeah,
Right.
a professional
Cost
engineer.
estimate.
Good. That works.
I'm not so sure that I would want 100% of the cost of that, a burden onto the, I think that cost could be split by the county and the provider. Cause it's kind of helping us too, to make sure that the numbers are right.
They're gonna serve who they're working for.
That is true. People generally serve who they're working for.
Whoever the payer, who's paying them, that's the one
Yeah.
they're gonna,
Whose budget is that coming out of, John?
yeah.
Mm-hmm. Well, I would imagine if they are to evaluate it for the county, then the county would have to initially pay them, and then that would be part of their fees in getting this passed.
Yeah, you could do it that way. You know, it could probably come out of professional services, but
Yeah,
And, you know, and then you have the scenario, say, where you have a company come in, they go through all the work, and then the CUP gets denied. I guess the county would be on the hook then for those costs.
Yeah.
Would there be an application fee that might cover that?
And that is done in one of those
Yeah.
ordinances we have, that we were looking at. They had a fee of $1,000 or something for the review.
And that could be part of that cost sharing, I guess. You know, we could just have a fee for the review because we may have outside help, and maybe that might be the cleaner way of doing it, is to set a fee that would be, the idea is that fee helps cover third-party review.
right.
I think we need to be careful, because when we start making special circumstances for one thing, that we have to treat all the other things
Mhm.
the same. So when you start changing what you're going to pay for versus what the applicant's going to pay for, we've got a lot of things in the county that come before the county commission and the planning and zoning. You know, all of the animal permitting, the marijuana stuff and things, and we require certain things to be presented, and they have to pay for that. Why, and I'm gonna ask the question, why is this different? Because if you can give a reason why it's different, then maybe I could support it. But right now, I can't support the county paying for, those things.
Do we require decommissioning estimates on anything else?
Well, no, because the wind ordinance needs to be rewritten, and the cell tower ordinance needs to be rewritten. We do require them to have plans, but nowhere in there does it say the county pays for those plans.
The difference that I see is the fact, like with a animal confinement, that's still the owner's property. That's their confinement. That's their property. Marijuana, that's still their property, right? Is there any other circumstance that comes before the county where we have a company that takes over private property, you look at that contract that I looked at, you own the land, you pay taxes on it, but that's about it. And this is a third party that's coming in. It's and that's what I was gonna get at, is the fact that, this decommissioning plan that I have, one of the first things it says, the owner of the facility is responsible for this decommissioning. It goes back to the private property. It says here, the person who owns the land is not the person who has control of it. They've given away their rights to use that land as they see. It's a third party.
But
But what you could add, the thing about it, what you could add is to say the responsibility of decommissioning is on the property owner.
And there was a county, who mentioned the county in Iowa who
Yeah.
does that?
Yeah.
If you put that in there, then I would not even worry about the decommission. I don't, because if it goes back, if you say it is the owner of the property that is responsible for decommissioning, it's their cost,
And to some degree, it's not the county's job to get into an agreement between a landowner and a business owner.
Yeah.
I rent my land for use, and it is not the county's job to step in and make sure I'm getting enough rent, or to make sure that they don't rape the land and put it back where it was. It's my responsibility to do that because my name's on the contract. And so I think we have to be careful with how we step into that marriage, if you will. Because once we start taking ownership of things like that, the can of worms really opens up, and then pretty soon we're poking our nose in other places. And I've heard over and over, we want to minimize regulation and promote business, and that balance needs to be balanced. And when we start poking in on those contracts, it becomes kinda iffy.
I think the reason the county has their nose in this is because of the fact that you have 1,500, you know, what's the county's main source of income?
Manufacturing, actually.
No,
Property tax.
No, property
right.
tax,
You
yeah.
have 1,500 acres sitting over by Vollen that's got solar panels on there. What's the value?
Taxes,
There's a centralized assessment that happens.
they'll be taxed.
You know, you know, and I don't know if this is for fact, but I've heard this, that people have told, you know, I've read this, that, you know, solar farm goes in, your property that's adjacent to it goes down a certain percentage of value.
Well,
You know, and I don't, like I said, that's not factual. I don't have any facts to base that on, but that's what, real estate agents say.
The
Yeah,
ag
so-
land would not. The ag
Yeah.
land is based on SDSU numbers every year, and it goes on an 8-year Olympic average on production. So the ag land sitting next to it would not change 1 penny from a solar farm. That's just how ag land is rated. And
Yeah,
some people
there's
would
a
think it's
difference.
not a fair system.
there's a difference between market value, and your market value might change, but your assessed
Your
value
assessed value
is a
won't.
set formula
No,
in
but
South
it-
Dakota.
Doesn't matter if there's an oil
And
refinery
I-
sitting next to your land.
And I did check in with Michelle, and we've checked in, and it's like, a solar farm would have a special assessment as an improvement. And so there would be additional taxes that the county would receive from a solar farm, from those properties.
Even if it's not working.
Even
Yeah.
if it's not working.
Yeah,
If it's
'cause there's
there,
value.
it's taxed.
You can have a vacant home, and it's taxed.
I guess, as far as any of these conditions, or, if we wanna have a third party look at it or whatever, I guess I would be more in favor that the applicant would have to front the cost of that instead of the county, because that's kinda the way it is for everyone else,
Yeah,
for every other
somebody-
application.
If somebody subdivides and puts a bunch of lots in for a plat, they're paying all the engineering costs, we're not paying a portion of that,
Yeah.
that's all done up front.
Right, so I think to be consistent, they should have to pay for that. And then as far as the concern of why are we having the decommission plan all formalized instead of just saying it's on the landowner, I guess if we wanna add something in there that it's on the landowner too, I would be fine with that, but I still would wanna see a decommission plan, because unlike if you're just renting out your land to be farmed or something, yeah, if somebody goes in there and rapes the land and ruins it, well, you still got a piece of land that's not that much different than what you started with. Yeah, the fertility might be gone, or it might be full of weeds, but that can be remedied fairly easy. If you've got a sea of solar panels here, we might not have landowners that are as sophisticated to know that, well, maybe a surety bond isn't good enough, or that these guys should line out everything that's going to take to decommission that. They don't know what they're getting into necessarily. People can be bought off with a good greasing, you know, so I think that we need to have something in there just so that us, and if we want to put something on the landowner, they know what's going on, and that company's required to tell them everything that's going on, not just, oh, here, we'll give you a big cash money for use of your land, and then 10 years later, oh, we walk away and it's your baby now, so.
Yeah.
And I can support that. I think Mr. Welsh had said a lien against land if project goes under. Could you have in there that any shortfall is a lien against the land? So if you've underestimated the cost and you've got $1 million sitting in the bank in your escrow account, and it cost you $1.5 million to clean the project up, the shortfall is a lien against the land. And that brings the landowner in, so everybody's responsible for something. And you can bet the landowner, I would hope, would be encouraging the operator of the solar to be above board.
What I like about that is that it keeps responsibility and authority together. So in other words, the landowner has the authority to lease their land to this company. And in the occasion when the company goes bankrupt and there isn't sufficient money in the decommissioning plan to keep the county harmless, then the landowner who has received leasehold payments is potentially liable with a lien against their land for the extra cost. I think that actually makes a lot of sense.
So you put this lien on, this lien is held by the county then?
Yes.
This
Yeah,
is
the
making
county
the
would-
assumption that the county's cleaning up the farm at that point, right?
No, well, the
Or-
county, somebody's gonna have to do it.
Someone's gonna have to do it,
And
yeah.
the thing about a lien that is very effective is that a lien, a tax lien, stands ahead of the line whenever there's a foreclosure.
Mm-hmm.
So in other words, if a bank makes a loan on a piece of land, the bank has to make sure that any liens are satisfied before the closing takes place. And so a tax lien by the county against the property would keep the county harmless. I really think, I agree with Chris though, that there really does need to be the detailed decommissioning plan, and that plan A is that the owner operator will deposit money in an escrow, and as we've described, there could be some combination of escrow and a surety bond, but there should always be an escalator clause that recognizes that inflation takes place.
Mm-hmm.
So far, what I'm just going to recap, because I've been trying to take some notes. So we have an escrow / surety section. Up front, 50% of the estimated decommission would be put into an escrow. 50% would be surety. There would be 5% per year added to the escrow through year 10, where it would be 100%. We would update the cost of that every 5 years, and that would be done by a professional engineer for inflation, et cetera. Am I right on everything there?
I think
I'm
so.
assuming that the
Mhm.
interest earned on the account would simply become compounded interest and stay in the account. That would
Yeah.
help to make up the 5%. Third-party review, and so at the end of that, any shortfall in the decommissioning project, the county has the authority to put a lien on the property. So you won't put the lien on when you give the CUP and start the project, you put the
Mhm.
lien on when there's a shortfall.
Exactly.
But
Yeah.
what it does in writing is it lets the landowner know it might be coming.
Yep.
So did I get everything in there?
I think
think
so,
so.
yeah.
Okay. Now, we didn't talk about liability insurance.
That's next.
That's next, okay, gotcha, because there was just some mentions up front. All right.
So on the plan development, we do want, they're gonna bring a plan forward to us. We want that to be we want them to shoulder the cost of a third-party engineering decommissioning plan.
Mm-hmm.
And so essentially a professional engineer developed decommissioning plan must be presented.
Which they're probably gonna have anyway. I mean, they're probably not gonna do that in-house regardless.
Well, you talk to any large, well, I know of the companies I know that make some of these facilities, they have in-house PEs.
Okay.
My friend is one of them, actually. He's an in-house PE for one of these companies that make solar farms. And so it would not be requiring a PE developed decommissioning plan would not be a burden, I don't think.
but requiring it to be third party, then that would give us the assurance that's a little less bias.
Mm-hmm. Is there any other requirements on what that plan needs to, I know we have, okay, well, we have in here in our draft right now is plan required, so we want to add that that's a professional engineering plan, third party reviewed. I think there's most of the language in there, it seems pretty standard in the, it has a 6-month, let's see, decommissioning must occur within 6 months if the plant is not in use for 6 months. Does that seem reasonable?
I think so.
I think, we talked about that at the planning commission, because originally when we had it wrote up, it was like 12 months and 12 months, which said, well, basically from, if something, say, were to happen to the facility, whether they stopped using it just because, or if a natural disaster destroyed it or something like that, you could basically stop using it and let it sit for 12 months before we even have to tell them to start cleaning it up. And then it could be 12 months from then, so basically 2 years from the time that something happened to it. It could be 2 years later before it actually had to be done and cleaned
Completed.
up, which seems kind of ridiculous. I mean, you could have something laying there in shambles for 2 years and not do anything with it, and we couldn't require them to do anything with it.
So this says, yeah, 6 months of no use, now you have 6 months to clean it up.
Right, so
And
that's
so that gives you
year.
1 year in total from the day you stop using it.
Right. Which we kind of felt like 6 months would cross over any kind of
Weather events.
weather events or whatever. I mean,
Mhm.
if it gets smashed at the beginning of the winter season or something, and you can't do anything with it, well, 6 months to start working on it. You should be able to get a plan in place and start working on it 6 months from then.
3 months from the
Or
time.
3 months.
Yeah.
Mhm.
I'm good with the 6 by 6
Okay.
by 6.
Well, like when it flooded, you know, there was issues where people couldn't either get someone out there, or, I mean, I think that's a good point. 3 months might be pushing it a little bit.
Right.
Yeah.
This one that I have, because I cannot wrap my head around this one to see why this is not covered, but what they have, the system is damaged and will not be repaired or be replaced. Would that be covered by what we have? I can't find a scenario in my head where that would not be, you know, we would already have that covered, right?
Yeah, if it's damaged and pulled out of use. well, that's-
6 months, yeah.
6
Yeah,
months.
because that's what I was trying to figure out why they have that listed,
Mhm.
this one that I have. And they also have the land lease ends. I don't see the lease ending. I don't see the company or the owner.
And then, okay, so is there anything else that we would add to like a decommissioning plan for the development outside of that? I don't, the only thing we have to add here is about the third-party PE review to what we already started with. So you want to go into the liability?
So the liability insurance would just basically be covering if somebody were to wander onto the property and get hurt and then try to sue the county or something like that?
Yes.
Well, it assures that they would be covered.
And us.
Well, it also, like in
And not
this
commit.
draft, it says name us as an additional insured.
Yes. It doesn't, I mean, it,
Mhm.
and what that does is, what that does by us being additionally insured, if there's any case that anybody comes up with anything against us, they're liable to defend us also. We don't have to go out and get a lawyer and fight the case
Mhm.
and all that kind of stuff. Which only makes sense because they're gonna be the front line and they know what's going on with this stuff, so why should we pick somebody up and try to jump in the ship also?
So in that case, does like we got in the draft here, $2 million per occurrence, 5 million in the aggregate, is that enough?
I would say so. I've never seen a $5 million one. It's usually one million and 2 million aggregate. But that's what I've seen. This is probably on a whole bigger scale, so I would say this is probably sufficient.
Yeah, I won't tell you how much liability insurance I have to carry all the time. But
Can we
I would
add-
definitely not go less than 2 million.
Right. Could we add something in there that we can use those escrow funds, cover deductible or any shortfalls, or not?
I don't think we
You're
wanna
not allowed
blend those.
mix.
I think we should keep that escrow clearly for decommissioning.
Yeah, I agree.
So just so everybody's aware, the cell tower section has liability insurance, a whole section 2521. And they require the wireless company to carry $1 million per occurrence, 2 million aggregate, and then auto and workers' comp and disability. They don't require the county to be listed unless the tower is on county property. There is nothing in the wind
Mhm.
about liability insurance. So,
That's probably something that needs to be updated too.
That is probably something that needs to be updated.
Yeah.
So
The-
I guess as well as naming the county, should they also have to name the landowner?
That would be up to the landowner if he wants to be on there or not.
Yeah,
He should
again,
be
I
on the
agree.
lease. I mean,
Yeah.
I would think that the,
I agree that we don't want to get into the deal between the landowner and the lease and the operator. So,
you know, and the liability insurance, they're gonna have it already. All they gotta do is write our name on the policy. Have their insurance agent put our name on the policy.
yeah, I just want to make sure that we're not making anything that's an undue burden.
No, I agree,
Yeah.
but I think this is something that we
Okay.
need to, just to protect ourselves. And like I said, they're gonna have it anyway, but we wanna make sure that we're protected too.
And
So
that,
we
and I
don't have to
guess,
go out
you know, if we're doing that here, then maybe we do need to update our other ordinances to have a similar policy.
those two need to be gone through, those two, 25 and 26.
Yeah, I think Don wants to tackle wind next, so.
Okay. Any other comments on liability? Kind of sounds like we're sticking with what is written for the most part. Okay, I think we are kind of to the end. Oh, power purchase agreement, we have that one last clause in there, and that's, when we go through that. Do we care about the power purchase agreement at all? Again, I feel like we're looking at a problem between two private parties that,
You know, I think the only thing there, and we ran into this with campgrounds, is they would be built and then they would call BY and say, hey, we're hooking in, and they'd say, and that's hence the reason why we have a new substation out there, is because they didn't have the power to do it, and that's why they had outs and stuff, because no one called them. So really, the intent there is just to say, does the electric company know? And it's gonna depend on the size of the project. As has been stated, if someone's sinking $10 million in, you can be guaranteed they called the power company and already sold the power. If someone's putting in 60, that's where you'll probably get, they assume that they're gonna take the power. So, just to make sure that,
okay.
yes, essentially a little thing says, yep, I've talked to Northwestern, or I've talked to BY, or whatever it is. I don't think we need the contract. We don't care what they're making on it, just that they have been informed.
Well, yeah, that's exactly right, because like BY, they have their buy all, sell all agreement at 50. Well, somebody might not know that, didn't do the research into it. I'm gonna put in 60 or 80 or 100 or whatever,
And then find
then
out.
find out, oh crap, I can't
Exactly.
do this.
Okay,
You know, so it's just making sure they're going through that whole list of stuff.
all right,
So
so
I-
it makes sense.
Yeah, and maybe it can be whittled
Yeah.
down a little bit to make it just, yeah, have you talked to?
Because, well, and it says if an applicant has executed a power purchase agreement, so,
Yeah, and we,
so it's not really any requirement there. But,
Yeah, I think that it needs to be reworded that somehow, that basically we made sure that they talked to the power company.
you have approval.
yeah,
Yeah.
so maybe just the note there for the commission, planning commission is like, yeah, that's pretty much our intent there, and so making that wording there clear. And we talked a little bit about the transfer. I was just noting also that I think it was the Lynn County one, has a whole section on transfer of the conditional use permit in the event that it's, sold to another company and now operated under another company. We've already previously talked about decommissioning plan being updated. Would we want them to come in, the new company come in and apply for a new permit? Can we make this permit transferable?
Well, we have some kind of wording with the ag facilities to that effect. It's right at the end of Article 5. Let's pull it up here.
It's on page 59, you're still looking. Of mine. So I can go ahead and
Yep.
read it.
Yep, go ahead.
For the purposes of this ordinance, any sale or transfer of the permit from the applicant to any other person or entity within 5 years of the date the permit is issued shall be considered to be, is it prima facie,
Fascia, yep.
facie evidence that such permit was obtained for the purpose of selling, transferring, or brokering the permit. The Board of Adjustment may hear and grant exceptions to this rule in the case of unforeseen life events that may force the sale of an operation. So that was put in there in case someone passed away and an heir would take over, et cetera. So essentially, within 5 years, you can't transfer the permit. Then the next says, any evidence that is presented by any person that any building permit and/or conditional use permit for an animal feeding operation, concentrated animal feeding operation, and/or waste facility was sought for the purpose of selling, transferring, or brokering the permit shall be considered by the zoning administrator, planning commission, and/or board of adjustment in considering a new application for conditional use permit. It may be the basis for a denial or revocation of an application, building permit, and/or conditional use permit by the board of adjustment.
I think we could put pretty much that same language right into this one and just change it instead
Mhm.
of animal feeding or whatever, just our solar energy conversion facility. or
I think so.
System.
Okay, so after 5 years, say it's year 6 or 7, they're free to transfer the CUP to a new owner,
Mhm.
essentially, and that's how normal CUPs work. Whether it's a bar or a daycare or whatever, they can
But we would-
transfer
But
them.
we would get an update on the decommissioning, so we'd be involved in some way.
Even
Even
after
Yeah.
5 years, yes.
Yep, because they have to fulfill all of the requirements of the
Yeah.
CUP.
So that makes sense.
So Gary, did you get that? 520, last 2 paragraphs.
You just want that as another item.
Yeah, it'll be listed in there somewhere. This one was in a separate section, but we can figure that out later.
Well, it's
Mhm.
actually the whole section 520, not just the last 2 paragraphs.
Did you want the whole section?
What page is that
I think
on?
it's on page 59. I think
Mhm.
it makes it a little more clear that we don't want somebody coming in here applying
Oh,
just to
yeah.
sell the permit.
Yeah.
Yep, there you
The
go.
whole
Sorry
section
about that.
520.
Chris,
Yeah,
I should have
pretty
read
much.
from the beginning.
Section 520, just
You had
applied
said 5
to-
years and I saw 5 and,
Mhm.
okay. Yep, you're right. So section 520, all.
So is the plan here that you wanna change this before going to planning commission again, or you want these just as notes? I mean, we're getting into quite a few details again,
Mhm.
so are we just wanting to make notes for planning commission so we make sure we cover everything versus putting this all into the Article 29 proposal?
I think the section 520 could just be almost copy and pasted right in.
Yeah, and then,
No, it's
yeah,
not
and then,
either way. I'm
Yeah.
just
Yeah.
asking
You know, I think it's a good,
how would you rather see it?
I think it's a good idea to put it in the document, and the reason I say that is, we all take notes, and if you're like me, you leave your tablet at home or whatever it is. So because we can always put the big old cross through it.
All I need.
Yep, thank you.
okay, do we have any other items that we need to add to this ordinance?
No, we've covered
Mhm.
setbacks, safety, and decommissioning, and as far as
Mhm.
I'm concerned, those are the key elements.
I did receive a call from a citizen and asked us to revisit the 660-foot setback off a property line in change of ownership. In their opinion, that will essentially prevent solar farms from being in the county.
A couple of those calls also.
Yep, You know,
and I had that, brought up to me too, but also, I personally brought that up with the ag facilities whenever all the Article 5 stuff was going through. And I said the same thing, that's pretty much going to outlaw any animal feeding operations or anything that applies to. And I was told by the planning commission and the county commission that I should just have better relationships with my neighbors to get them to sign a waiver.
Mhm.
So, I
It
mean,
does-
if it's good for the goose, it should be good for the gander, in my
Yeah.
opinion, but.
If you have the same waiver clause that you can have those setbacks wavered if you personally work with your neighbor. I mean, it does require a solar farm now not to just to even think about getting the permit, getting the leases on land in an area, but also the area around it. Now they have to also get permissions to possibly make the use of their lease. And so,
Yeah, I
Any-
think we talked about that when Guy Larson was here, that you know, he stated that he would be more than happy to have one of these in his front yard, and I said, then you can file a waiver and you can have it there, but if other people may not be okay with it, and so I agree with Chris that
Mm-hmm.
it's good for the goose, it's good for the gander.
Yeah, I mean, I think it's a pretty big setback, 660 feet.
You
And-
say the same thing about our building setback is 50 foot.
Mm-hmm.
There's some places buildings are built that shouldn't be built.
Mhm.
But again, it's their property and their right, and you need to look at the, how it influences the neighbor. You know, when you have your 5 senses, you can see it, you smell it, you can touch it, taste it, and feel it, if you will, and probably seeing and smelling are the 2 big ones that as you go through this whole ordinance, and that's what your setbacks should be based on. You know, can it contaminate a stream? I guess that would be the environmental setback, et cetera, but it's something to consider.
Do we want to entertain reducing that setback?
I would be interested in reducing it to half.
To 330 feet?
You're still gonna have to get, in certain locations, you're still gonna have to get a waiver.
Mm-hmm.
I think that if it's reduced there, that it should be reduced for everything. I don't think that it
I don't
should
have a
be-
problem with that either.
I don't think it should be more restrictive on local landowners than it is on an outside company coming in to build
I
a sea
agree.
of solar
Mhm.
panels.
I agree, I don't even, and whatever agreements or whatever, hog barns, you drive by them on the road, and we drove by one Sunday coming back from our home church up north, and it was a huge hog barn sitting like in Hutchinson County. I don't think it was 100 yards off of or 500 feet off of the road, and we drove by and you couldn't smell anything.
Mm-hmm.
And there was no breeze, no wind from any direction. I'm not saying that they're all like that, I'm just saying that to me,
And
330 feet,
I think one of the things we have to consider, and we're talking a lot now about the CAFOs and the hog barns, we shouldn't muddle this with those politics. We should really be considering solar farms and them directly, I think, in this. And not, that's a discussion for another day, but it's a fair point, you know?
and we still have a decent setback from a residence. So
And we still have all the setbacks from residences.
The Lynn County does use, the size of like 0 to 40 acres, 40 to 160 acres.
Mhm.
Anything over 160, and they have a graduated setback for those, 25 foot, in the 40, 50 foot in the next tier, and anything over that's a minimum of 100 foot. But they do require a planted buffer zone along the edge of the property too. So it's just something to consider on,
I guess it really does depend on the size of the facility.
Yeah.
Obviously, if it's going to be whatever, 100 megawatts and it's gonna be the size of this, or 100 kilowatts or something, and it's gonna be like the size of this parking lot, that's different than 1,000 acres. If we're talking even a few hundred acres, or even just 100 acres of solar panels, that's a massive thing sitting out there, and 600 some feet doesn't seem like, in my mind, it doesn't hardly seem like enough in that case. But if you're talking a smaller project, I guess a graduated scale I could see, because if it's something small, why does it have to be that far away.
Mm-hmm.
So if someone, and I'm sorry to show my ignorance on this, but if someone comes to you for a conditional use permit, isn't that what they're really asking for, is an exception to the ordinance?
Well, an exception, you'd be asking for a variance.
Right.
In a conditional use permit, you're asking that to have a permit for this, as a possible permit for it, but it still has to meet all the conditions.
I see.
Yeah, you can't change setbacks.
Okay. So is there a possibility of changing setback requirements with a waiver from the individual affected, Gary?
The ordinance does have in there in certain locations that the setbacks can be waived. If it affects a homeowner, et cetera, they can say, doesn't bother me, put in whatever you want to,
Mhm.
and then you're excluded. So that dot is off the map,
I see.
so you can do that.
So, go ahead.
You know-
Doesn't happen often, but it is possible.
Could, when we say right-of-way line, typically in South Dakota anyway, that means a section line. If I'm not mistaken, every section line,
Yeah, roadways.
A roadway, yeah.
And-
No matter if it's township or
Right.
state or county.
so that's 330 feet. Why would that be different than property line delineating a change in ownership? It almost seems to me like they should be the same. And, 330 feet is a little over a city block. That's quite a ways. And that's, most people wouldn't be bothered by something like this that is quiet and no higher than 20 feet in height if it's a city block away. So I guess I'm kind of leaning toward John here and thinking that maybe 330 feet might be the correct number for a property line delineating a change in ownership. And that would keep it consistent with a right-of-way line.
And I think one of the interesting things about this is, you're gonna have a company come in and they're looking to sign leases with existing owners, and so they could have one of these property lines right going down the middle of what their planned project is.
Could be.
And so they would have a 1,320-foot swath that they have to,
Yeah, we don't
Then-
want that.
well,
Then they could get a waiver
you
from the
you could get a
landowner.
waiver there,
Yeah.
yeah.
You know,
As
but
long
there
as
should
there's
be
a
a,
waiver, as long as there's a waiver option available under common sense situations such as that,
Mm-hmm.
I'm fine with them as we currently have them printed. Because you don't wanna get yourself in a box where you, as you point out, Ryan, somebody ends up having to have a, quarter-mile swath in the middle of their, project.
Mm-hmm, yeah. So, and when I've looked at ordinances in other states and stuff like that, it's been anything between 100 to 500 feet.
Yeah.
So 660 feet is greater than the 500 feet, which is the highest I've seen. But we also have there's a path around it too, so.
Right.
But even though there's a path around it, wouldn't it just be easier to say, make them the same?
Yeah.
Could just be easier to make them the same, yes. Because it does
And then
seem
still
weird.
use the path if you need to.
Yeah, it does seem weird to have the right-of-way line smaller than the change of property line.
Yeah. I think lake, river, and stream is fine. I think municipalities is fine. I think residents, active church and business and schools is fine. It's just that we have this right-of-way line, property line dilemma.
Mhm.
I don't see why they should be different, frankly. I don't know. What do you think, Chris?
I think it makes sense.
All right, so
330 feet for each of them, it makes sense to me.
let's reduce I think we're in agreement to reduce the property line delineating change in ownership down to 330 feet
Makes sense.
to match the right-of-way line.
Yep.
Okay, any other items that we want to cover? Sounds really good.
Can I-
Sounds like,
I was just gonna say, going back to, I don't know who brought it, I think it was Lynn County, but I know I've seen it other ones. Is that something that we want to get into the weeds? Because I know, like, like Chris said, if you have a solar farm that's 100, a couple hundred, a couple acres or whatever, it's so different than 1,500 acres. And do we want to get into the weeds and, and make the setbacks different? Because that's the thing I just always come back to, to make one size fits all. I mean, if you have a couple hundred where, compared to 1,500 acres, I mean, man, if I have 1,500 acres of solar panels, I would want spruce trees and a berm and, around it, compared to if my neighbor just had, a couple acres, be very different. So I don't know if that's something that we, when we get into planning and zoning, do we want to look at that?
One of the questions that, this goes to a question Chris asked when Stephanie was here, and that is, what's the scale that you would have to have in order to come up with a unique sales agreement with the power company? Stephanie gave us a figure of 1 megawatt is on 7 acres, I think, if I remember right. And yeah, that's right. And so, scaling it up, I don't see how anyone could operate or would want to invest in a, quote, solar facility, whatever name we gave it in here, SECS, unless it's at scale. I mean, it has to be at least, you would think at least 20 megawatts in order to get, BY Electric and their energy suppliers interested in talking to you. If you're not at that scale, they're not gonna be talking to you.
Right.
And that's what we're really dealing with here in this ordinance, is people who are doing this at scale. So I would kind of tend toward keeping the setbacks where they are, rather than trying to,
I agree, we might be making too much work for us, because again, none of this applies to anything under 50 kilowatts.
Right.
So, the home or the direct use stuff, it doesn't have these setbacks.
Right.
Right. And I guess,
Basin Electric is not gonna talk to you if you're producing 1 megawatt.
In my research too, is you have to be, it looks like the power companies probably won't talk to you unless you're over 20 megawatts in plan.
which then if you're over 20 megawatts, 7 acres is
140 acres.
140 acres, which is
That's a quarter
pretty
section.
big.
Yeah.
I did do a little,
Not a quarter section with a 330-foot setback around it.
You're right, you're right.
I mean,
It's probably
so,
half a
so
section.
then you're pushing it on to another piece of property.
Well, 330,
and
yeah.
stuff,
it-
so unless you get
yeah, I don't know
waivers and all
I
that, so.
haven't done the
Yeah.
math, but you're right. It would be more than a quarter section.
I mean, you would be looking at something, the smallest, it sounds like under our rules now, the smallest feasible farm would be a half section.
Yeah.
yeah, and I guess I looked at the tax credits a little bit and it doesn't seem to be size dependent. Pretty much do whatever, so, even for the industrial scale, you either get a 30% credit up front or you get a payment per kilowatt,
Yeah.
so, for 10 years.
All right. Any other items to discuss? Okay, well, sounds like we are at the end of the task force duties here and ready to pass this on to the planning commission for them to finish it up. So I think we went through a lot of stuff in a very short amount of time, so look forward to hearing this debate continue on the planning commission. Hopefully it was, hopefully, Sherry, you got a lot of notes.
Always have more than I, if I can read my handwriting.
Mm-hmm.
Between the two of us, we should do okay.
Okay, I will, at that, I think we will be ready to adjourn for the final time. And I'll entertain a motion to adjourn.
I so move.
Second.
All right, all in favor, say aye.
Aye.
Opposed? And we are adjourned.
What did you say those tax cuts were? What did you say, 30%?
30%, and there's some other factors that can bump it up to 50% actually. For different things, but
And then you said per kilowatt, right?